Dear students, my name is Dr. Gurpreet Singh. I will deal with international trade law. This is an optional subject in LLB semester 5. You can choose this subject if you want to know much about how the international trade is being done. When we talk about international trade, now in these days it is one of the hot topic. The reason is quite simple. The trade war which is going on between the United States and all over other countries is one of the most critical war of our century. Just like the United States, which has been imposing the unilateral tariff upon various countries, including in India, it becomes an alarming situation. Second most important outcome of this international trade law or international trade war is that international trade law which once established a WTO, which is a world trade organization to deal with international trade, and which is based on international multilateral institution. It seems to be crumbling down under the pressure of the United States. Instead of the multilateral organizations like WTO, now this seems to be an age of the unilateral or the bilateral agreements. The agreement between the two states, and more specific, these agreements are known as a free trade agreement. Just like India is also trying to negotiate the free trade agreement with the United States. Therefore, international trade law is one of the most important subjects regarding knowing how the international trade is done, what are the important institutions, what are the important international legislations, conventions, and treaties. Therefore, this subject has become very much relevant in the present time. If we look at the history of international trade law, we have to go back to the uh, 15th and 16th century in the Europe when the mercantile law came into existence in the Europe from the customary practices of the European traders. Now, these mercantile laws used to govern the individual traders in area of contract, partnership, trademarks, and various other aspects of the buying and selling of the product. Gradually, this mercantile law spread in entire European countries, and primarily they were based on the Roman laws, although some Germanic influence was also there. And this mercantile law is the basis for the modern commercial law or modern international trade law. When we talk about the modern international trade law, it is basically based on the free market economy. Now, what do you mean by free market economy? The free market economy based on the liberalism uh, uh, ideology, which is based specifically on the principle of laissez-faire. Let the country be free to do the trade without any restrictions by the state. So, under this theory, there must be less interference by the part of the state, and the traders or the big companies or other, they must do the trade without any such kind of interference. So there is under this theory, the purpose is to reduce the trade barriers as much as possible, so that the state could do the trade with each other without any hindrance. So present theory is based on the open access to the domestic markets without any hindrance, without any restrictions. But now, because the trade war, it seems that the trends which has been shown in the world at present time is contrary to this free market economy. Now states are trying to put more restrictions to the trade barriers, meaning thereby they have been adopting the protective principles, to protect their own domestic trade, and that is one of the contesting point between the India and the United States, when India and the United States has been negotiating regarding the in uh, regarding the uh, free market uh, trade, or regarding the this FTA, free uh, trade agreement. Second very foundation of this international trade law is the second principle of comparative advantage. According to this principle, if a country A is good in one product and country B is good in another products or goods, they must trade with each other, because by doing so, it will give the benefit to both. Therefore, it will bring a comparative advantage. Meaning thereby, if a country is not producing some other goods a very at very uh, 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 large scale, or it is very efficient in producing in that goods, it should not produce, rather than it should import that goods from the other country, and other country must also import the goods in which another country is very good, meaning thereby it will bring the comparative advantage for the both country. The another important principle which is regulating the present international trade is that international free trade, the liberal trade policies will sharpen the competition, motivate, innovate, and it will bring the success in many fields. So this is the first part of introduction, which is the general introductions. Now coming to the second part, that is the general agreement on tariffs and trade, which is known as a GATT. This GATT came into existence in 1948 and it continued till 1994, although it does not come to an end in 1994 when the WTO, World Trade Organization, came into existence. GATT in new form came into existence in 1995, so it is still continued process. However, the birth of GATT was purely accidental. Why it was purely accidental? Because before the birth of the GATT, the European countries were negotiating on one of the most important international organization, that was known as the International Trade Organization, ITO. But ITO was not materialized, and the reason behind is that the United States did not approve the ITO. Therefore, the temporary arrangement was made, and that temporary arrangement was the GATT, General Agreement of Tariff and Trade, which will regulate the international trade temporarily. The second thing which is very important is that GATT had a very narrow scope. It only governs the goods, not governs the services. Services was added much later on. How the GATT used to work? It used to work through the various negotiation rounds. So from 1947 to 1999, various negotiation rounds took place. Under this negotiation rounds, these were basically concerned with the reduction of the tariffs on goods and non-tariff barriers and anti-dumping. Now, what trade organizations? As I have said earlier, that GATT, the basic GATT was the basic form for the negotiation of the international trade, and it worked through the various round. One of the most important round under the GATT was the Uruguay round, the Uruguay round. It took place from 1986 to 1994. Very long debate, discussion took place in Uruguay round, and ultimately the World Trade Organization was came into existence through this round. This is one of the most important outcome of the Uruguay round, and WTO is one of the multilateral uh, multilateral system where the various countries of the world are the members of the WTO, and it has various different kind of structures, and one of the robust structure is the dispute settlement body of the WTO, which is also known as a jewel in the crown of the WTO. Now, what are the major principles of the WTO? WTO has three major principles beside other two more important aspects. First principle of WTO is the principle of non-discrimination, meaning thereby all the member states of the WTO well do trade with each other without any kind of discriminations against each other. Second principle of national treatment. In simple word, principle of national treatment means that how a state governs its own goods in domestic market, it will also govern the similar goods of the exported countries in its own market. It would not make any kind of discrimination the goods which is produced within the country and goods which is imported from the WTO member states. That is known as a principle of a national treatment. Principle of most favored nations. Principle of most favored nations under the WTO is that under certain exception, a state can extend the most favored nation status to the another country on account of its historical ties, on account of geographical boundaries, or some other reasons. But it does not mean that it will violate the principle of non-discrimination and principle of national treatment. In fact, this is the principle not to favor anyone. It means whatever the benefit, whatever the tariff reductions, if you have conferred on one state, you have to confer on the other state under few exceptions. Then there are two more very important aspects under the WTO is subsidies and countervailing measures. If a country is giving the highly subsidies in order to counter that highly subsidized goods, the state can impose the countervailing measures. There are certain rules and regulations which are governing them. Then the last is dumping and anti-dumping measure. Dumping means to dump the goods uh, in order to destroy the market of the another state. If a state is indulging in dumping the goods, then the another state has right to impose the anti-dumping measures. So these are the important principles under the WTO. Now, what are the structure of the WTO? The structure of the WTO is that highest body of the WTO is known as a ministerial conferences. Uh, it it meets to once in 2 years. It is the body which discuss about the international trade, negotiate the international trade. It offers the states to come together and discuss about the future policies regarding the international trade. In parallel to this body, the General Conference, which is a permanent kind of body which always keep on meeting regarding international trade policy review. So General Council meeting as a trade policy review body means they will review the international trade. So there are a lot of negotiation committee regarding the international trade, and under them there are very important councils. These are in three number. One is Council for Trade related aspect of intellectual property rights, Council in Trade and Service, Council for Trade in Goods. So meaning thereby that at present the WTO has a very vast scope. It is not only dealing with the goods as GATT used to be. Now it is also dealing with the intellectual property rights as well as trade in services, and further it has committees. These committees to assist the council in the various aspects. And last but one of the most important body is the dispute settlement body. If the dispute arises between states, state party to the WTO, they can bring the dispute to the dispute settlement body. It has a two-tier system. The first is a panel stage. The dispute will be given to the panel. It will discuss and it will give the uh, decision on the basis of the hearing of the both parties. Then if the party is not satisfied with, then the dispute could be uh, appealed in the appellate body, and the decision of the appellate body would be a full and final, and appellate body is a permanent body of the WTO. So therefore, the WTO is now one of the most comprehensive international organization which is the dealing with the various aspects of the international trade. It provides a framework for the administration and implementation of the agreements. It is a forum for the future negotiation and dispute settlement. And WTO also provides for the trade policy review mechanism. It promotes greater coherence among the members, economies, and policies. So therefore, WTO is very important from that aspect. But the only trouble is that what is the future of this WTO when the trade war is going on between the entire world in one side and the United States is on another side. So how the WTO will survive, and again there is also a question regarding the appellate body of the WTO. So these are the very vital questions which we will discuss during this course. Now, the second part of international trade law is that there are three topics. One is international commercial terms, then, or you can say in another way, contracts. There are three major terms which are used frequently in international commercial transaction. One is CIF, cost, insurance, and freight. Another is free on board, and a third is free alongside ship, FAS. Now, these three terms are the standard terms. The purpose of these terms is to regulate these contracts, and it also provides the rights and duties of buyer and sellers. So what do you mean by these three terms? What kind of rights and liabilities are there? We will discuss when we will discuss about these eco terms in part 2. Second is very important in payments in international trade, how the payment is made, meaning thereby what are the secure mode of the payment when where the both seller and a buyer could have the assurance that they would be paid if they will do the trade with each other. So there are two important mode which is used by the international traders. One is bill of exchange and another is the letter of credit. Now, what do you mean by bill of exchange and letter of credit? What rights and duties are there when the responsibility or liability of one party begins or when it comes to an end? This will be discussed in the part in the topic 2 of the part 2. And the third topic of the part 2 is carries of the good by the sea, the how goods are carried through the sea, what are the important modes, and there are again two bill of lading and charter parties. No, again these bill of lading and charter party consists about whose duties and who have the liabilities, who have the right to claim in the case of the loss. These all are to be dealt by these two kind of mode of carriage of goods by the sea, bill of lading and charter parties. So second part of the international trade law is concerned with the basically international contract, international payment methods, and carriage of the goods. Now, what is the objective of this course? Why this is taught? The objective of this course is very clear that international trade is one of the most important subjects as in when we are living in a globalized world, when international has become a small village, when you have the access of every information, everything now, when the interdependency among the state has grown up to the highest level and trade is the basic foundation of all. Therefore, international trade law is one of the most important field of the international law. So what are the object? The object is to make the students are familiar with certain legal principles, concept of international trade laws, and develop the critical skill among the student so that they can understand and analyze the international legal trade mechanism, international legal trade policies, and to critically examine important policies decisions pertaining to World Trade Organization, treaty negotiation outcomes, as well as decision of the courts, tribunals, and quasi-judicial bodies. So with this, thank you very much. I hope I tried to highlight certain very important aspects of international trade law, why it is important, and how it will give the benefit to you. Thank you very much for your patience listening.